Abusi anwumre ya samu ajo makwaba amanyo senjuma die na guso awohwe original TV fi sabre kwesi no ba ko bebo no Ghana honkomo ne ba be die nsema hodo bebre na atwetwe kuri na no ya wada ye di nkra ya ba ye ba be pense ni nyina me ka wo se ene asinof ye by election no that's what news since last weekend. NDC for high-level allegations against the Electoral Commission and the New Patriotic Party (NPP) and the Electoral Commission for a response about though NDC for say and tussle. The same as saying of by-election, the idea could be a Supreme Court ruling. Now Supreme Court ruling on the by no or man for or more reasons or more so a pass on judgment and then abriwe pumakwem amomode aba and some Crawford raises some concerns about Supreme Court of one casa ruling on the by any constitution once and some a beji brand ya fa kakra near percent people if you know make our social life original TV social media handles in active Instagram, Twitter, Facebook, TikTok, Nino Original TV GH, YouTube channel Nino Original TV Ghana fully honso may be to me and koye. And also my fadia always let me see my iPhone ha a MG way adaruma and no me tramisa no say me simple. I never come manage away MG for when say yen konko ye colors chin na multicolored down the mass say be why I say aboasre was against you colors there be try near try my mema 360 yeah very simple so lura ya hu ya no yes and so I recommend say Ira lunch about to be president MG yeah where and be official costume provider we provide at the amano monta the boss and the way kwa omo betime twa material and the amount kama simple. We did this amount to the captain of the dress ship and I've been foul break and remember a year guest no I am more a year talking our hasi but young corner NDC for issues of marriage against the Electoral Commission over the weekend Nina is about a sin of by election no na the NDC for NDC for let the bar about saying issued by the communication director lawyer Sami Jamfi on 4th June was yesterday, and no more issue say NPP and the Electoral Commission in a plot to illegally insert the name of an unqualified NPP parliamentary candidate into the Asin North voters register. Or say NPP in the Electoral Commission for enam kuntra se person mo fasuma se e de openibi on never NPP for person obejina ko by election wo mudi momo e din kwhye voter register nipa non qualified. Or say the National Democratic Congress has become aware of a plot by the ruling New Patriotic Party, acting in co-host with their collaborators in the Electoral Commission to transfer and insert the name of one Charles Opoku into the voter register of the Asin constituency. This illegal move is to aid the said Charles Opoku to contest in the NPP parliamentary primaries to select a candidate for the upcoming Asin by-election. Or Chester or more NDC for Omahu, say Electoral Commission for being near MPP for committee upon some person of their brandy and did Charles Opoku Edikoshe voter register a war as seen of from Nipan and Twaba or Promise of the Nukoshimu. Our unimpeachable sources have revealed that to the clear requirement on the nomination form for the Asin North by-election, which demands the candidate in the election must be a registered voter in Asin North. The said Charles Opoku is not a registered voter in Asin constituency. Was said that she city or by election no we be or bet me a contest in the same panel free Asin about to impesu so no or to a banner in Dinwo about to woman was in of necessary Charles Opoku mo can answer me or no on to aba a year constituency. It is instructive to note that according to the regulation 22 of the Public Election Regulation 2020 CI 127 voter transfer can only be offered. Voter transfer can only be effected for an ordinary citizen not less than 42 days to the public election. More importantly, transfer application can only be made to the returning officer of the public election, given the fact that the said have less than 42 days to the election day in Asin North, and returning officer is yet to be appointed for saying any transfer of voters to Asin North will be unlawful and same shall be fiercely rejected. Was it said the Amranicity? No, so being probably voter transfer, I was said 42 days to election. Now, saying of election, I free Saturday 27, 42 days in will be entering transfer the vote to call. You can transfer the vote to call, say, yeah, the returning officer, the electoral commission, as you speak. I feel the electoral commission be up until a returning officer, and or more NDC for my quite that, and me and transfer will be a D and Concoshimo. We are closely monitoring this situation and shall take every legitimate step to ensure that this illegal plot is not perpetrated by the Electoral Commission and their collaborators in the NPP. Also, many for the many better for my say, found on by Chinchan and Chomon Emma Sa and Montuboni way Emma so Nipa was signing a NDC a year director and National Communication Officer, a lawyer Sami Jamfi. Now, young call Electoral Commission, Electoral Commission for social response or more a day a buyer. Electoral Commission for responded to us say. NPP and the Electoral Commission in a plot to illegally insert the name of an unqualified NPP parliamentary candidate into the ASINOF register. So this is the Electoral Commission a year response. So the Electoral Commission's attention has been drawn to a misleading press statement attributed to the National Communications Officer of the NDC, alleging collaboration between the NPP and the EC for the purpose of transferring the vote of one Charles Opoku to the ASINOF constituency to enable him contest the upcoming by-election in the said constituency, or say Electoral Commission for a year NDC for Nsamomoka. We wish to state that this is not true. For the record, the EC has not received any such request from the NPP to transfer the votes of any person. This allegation is false and a figment of the author's imagination. As usual, it's the aim at maligning the integrity of the Electoral Commission. Electoral Commission said, no correct. Electoral Commission said this if NPP form a country and some more transfer be a vote to their core constituency. I don't know we are some NDC 4% more year normally go Electoral Commission for whom we feel. Per Article 94 of the 1992 Constitution, a person does not need to be registered voter in a particular constituency to enable him or her contest election in that constituency. Per Article 94 of the 1992 Constitution, a person does not need to be a registered voter in a particular constituency to enable him or her contest election in that constituency. Per the Constitution, simply hailing from a constituency entitle a person to contest election in that constituency so long as that person is. Or say Emramono and says so be free constituency be muse ni kromonians with matter but say nipa ne to won kwa Emrama ho kwase ne nipa ne to abamani yeye. Sa nipa no so you be a Ghana ni 21 years and above of sound mind and a registered voter. You be a Ghana ni wadi mfie aduonu baako ene ekro na nadwimu eda honom na osa ewo ni voter register watro ni din wa abato trongumanum. Or say in an event where a person who wishes to contest in a particular constituency does not hail from that constituency, the person will be eligible to contest if he or she is ordinary resident in that constituency or has been a resident there for a total period of not less than 5 years out of the 10 years immediately preceding the election for which he or she stands. Nipa ni from pona nipa na tena constituency no mu be mfie no mu kwa nipa ni timi contest mani yeye. We make this point to buttress the fact that a person who hails from a constituency per the constitution need not to be a registered voter in the constituency he or she wishes to contest in a simply hailing from the enough. As such, there is no reason for engage in transfer as being alleged by the NDC Communications Officer. It is a well-known fact that the current commission has been the most transparent and accountable in its operations. The commission has carried out its mandate in strict consonance with the Constitution. So, Electoral Commission is almost there, almost Emran almost there, Juma. Na the NDC for Kanina and Tintin Tiawa. They say, "Enyesa netie." Na statement in Hana and to date, the NDC has not proved a single allegation that. To date, NDC has not proved a single allegation they made against the EC the continuous aligning of state institutions such as the EC by the NDC only weakens and undermines our democracy. The EC will continue to uphold transparency, fairness, and integrity in all its operations. We urge the good people of Ghana to trust us to continue to deliver credible elections. And the Electoral Commission says some more quite NDC for Kenya, Mubia and one more multimedia dance here, they are back. And the person who Electoral Commission who fee, or more catch the Ghana for share boss, or because I Juma no credit, mu prepare ye, French ye, celebrate me as some Ghana for ye. This is the issue. But NDC for allegation here very simple. Sir Brante be a friend Chas. Uku. On to about her anything in Kwakoshemu. But the Electoral Commission statement failed to respond to that. The Electoral Commission says was spelling out the constitution and the regulation. Say you don't need to be say we a native of African constituency. What 5 years the constitution, what the 21 years, what you da how voter register to. But NDC for allegation is a new panel. The vote any constituency ni ho e no to aba and on person for continue as did Kokoshem. But this statement failed to respond to that part of the allegation being leveled against the EC by the NDC. Now the same as a North by election. The idea call when you na a Supreme Court ruling omo ede eba na ruling omo de buy no ene na enchechemu ebi aba na enchechemu na aba no nkrofo raise a lot of concerns about and some hodwa Supreme Court for nankasa ede aba ewo mu ruling no mu na ensemu a ebinumu bisa no. Let me try and get some for you. Okay. And this way Supreme Court ruling na oba esro ha say mo Supreme Court judges no echire yeni. Section 20 grounds for cancelling election results. Electoral Supreme Court said the omugina so etwa yewra jachi kwesi about where to yedi yi no no ensunsan so mutwa mu no eni. The election of a candidate shall be declared void on an election petition if the High Court is satisfied that general bribery, general cheating, general intimidation, or other misconduct or circumstances, whether similar to those specified in this law or not, have so extensively prevailed that they may be reasonably supposed to have affected the results of the election. Say, Ghana Constitution say, we will bet ma to abama ne betimi atwam. Se nipa no etwe da mudie. What they say be tintintinti titi amra so a cheso amamra nya adwuma na sesa oni kura ne ya ba High Court ehwe se asem no to asumu a otimi twam. That there has been non-compliance with any provisions of this law or the regulations made under this law, and that it appears that the election was not conducted in accordance with the principles laid down by the law, and that such non-compliance affected the result of the election. Sir abato ni amfam na kwan so ene de to aba no na mrakwan ya fa so ntenya nsunsuan so abato no nsunsuan so a entimi gina so etwem. C, that a corrupt or illegal practice was committed in connection with the election by the candidate or with his knowledge or consent. Engagement of the candidate or say nipa na aba na ekoto ne kanka ne prejuri bi akoso say nipa na so no ankasa ho forum bi ananse hu nipa bi na forum hu bi no etimi nyina so etwa aba no mu ubedi na anoma asake ho no say that the candidate was at the time of his election a person not qualified or a person disqualified for election. Say nipa no ebra ye beto aba yi no sa abra ne beto aba yi no say nipa no onsem fata e wo mramu say wotimi to aba say nipa no o say oye Ghana ni nipa no o say wadi 21 years and above nipa no so oye registered voter nipa no so oye sound oye minded as ni na dwumu da ho say o nipa kro na at the time oye kwakoto aba no say nipa no qualifier court etimi twa oye abato no sunsuan so enti we Supreme Court so this is what they quoted omo enchire mo omo ede aba. Now oto aso echo the same Supreme Court ruling na oba ha say ya de omo akire wa ha ni or say citizens of Ghana or another country could simply throw affidavit or declaration at the state and deem themselves divested of citizens if they find a reason to quickly remove the burden of that citizenship from themselves because of changed needs. There would be no need for a certificate of renunciation issued by the Canadian authority to take effect from the 26th November 2022. Enti osoma sanse yewra eye jachi kwesi at the time wa okwa file eye 2022 no na chese sabre no de ne Canadian eye letter dey atum so omo renunciation be take effect from 26th November 2020. Na election is 7th December 2020. Now, what was Naka was say in the same way that the obtaining of alternative citizenship is done through due process and by legal means, we are satisfied that without a legal records granted by the state that conferred the alternate citizenship, persons who present themselves as having renounced their alternate citizenship can be accepted as having done so, unless they show an official record stating so from the alternate state. To accept such a position, such a proposition will make a mockery of weight that Ghana and the state place on the grant of citizenship other than through birth and the right and obligation that goes with holding allegiance to the state. The Supreme Court can say, na say nipa no obeka so mama apply mensan tumi nkan omo namra mu ni de e wo say sabre no nipa no apply nya say miguso ameye wo say waye bibia awie no saka ne krata che say oma no de krata de adase be so nipa simesi na obenten say wonye a citizen biom wonye a member pium. Na auto as I say this court has to therefore reiterate its earlier conclusion that the qualification of holding only Ghanaian citizenship must be present at the time of nomination and not any date thereafter. In this case, by 9th October 2020. And the Electoral Commission open nomination, which is 9th October no open nomination. And the Supreme Court at that time, na Yewraja Chikwesi, na the renunciation no omonya ho adwuma nwie. Though the constitution say nipa no at the time wa ye kwakoto aba ama no say nipa no qualify to mutual results no. But Supreme Court say omo no the omo interpretation of the law and say time e be nomination is part of the election. And by the time e be nomination and public nomination forms, if that person doesn't qualify, I will say it mutual. Because the BA nomination, the nomination was open on 9th October 2020. And I yet to abano December. So let's say 2 months later, and then the to abano. By the time we are to about December 7th, no opinion and crata na but now you're ready. But Supreme Court said on tiki and no. Name by the time we are October now a BA nomination cover form so no. Now and crata and you're ready to non qualify and into no major so a tremor. Now to us I say, since the first defendant had not received his certificate of renunciation as a Canadian citizen as of 9th October 2020, then he was not qualified to be a member of parliament at the time that he filed his nomination papers, at the time he stood for election, and at the time he was declared as elected member of parliament, because he owned allegiance to another country as 9th October 2020, the date when he should have satisfied the qualification criteria. And the way a Supreme Court ruling, the Constitution, as I can say, by the time Nipano over the requirements, the ultimate now so say that the candidate was at the time of his election, a person not qualified or a person disqualified for election. Election a process and a event. Electoral Commission open nomination one process. So be kwa nomination no na wako fele one process. Okay. On the day of election also one process. The Constitution knows that this is the process, but the Constitution states fact, and as a categorically say, at the time of election. And see, by the time of election, na Ghana date they record to about December 7th. And we be back say okay, say time of election there, you to about December 7th. As at the time you kwa to about no, na say nipa no qualify. The question, the answer is yes, because at that time no, na jachi kwesi na nkrata na be ready. And the question is, the Supreme Court to say as at October 9 no, Electoral Commission open nomination no, na ye jachi kwesi na or qualify. The answer is no. Sabre no wa file banana nkrata na ready. By the time you got to about the constitution at the time of his election, no, at that time the nan nkrata na ready. So and Ghana fu be edi se bi Supreme Court atimon hu yaw. This is a matter of law. Minim say dey so wodwen send no message ni fabre yankenkan empama na yebedi hu komo. This is a matter of law and common sense. Me see any law I be interpret here e be defeat the logic and common sense is problematic. Because law, you have the natural justice, natural law, common sense and logic, any idea law. And to say the same common sense and logic, ain't me, and rule, money law, management, a problematic.